Coming today. Okay, now let me start officially. Thank you all so much for coming today. Really appreciate this. We are so excited to have Scott Oswald from the Employment Law Group. Just to give a quick bio about Scott. He's an accomplished trial lawyer who has brought more than 40 trials to verdict and recovered more than $300 million in judgments and settlements for his clients in cases ranging from wrongful termination to employer fraud. Mr. Oswald litigates employment lawsuits nationwide with a special focus on whistleblower matters. And so really what we are very excited to have today, I'm not going to go quick, I'm going to go through your whole bio, Scott, because I want to get us going. But really, I am excited about you presenting this case study. And I think that the fact that we have people who are on this call who are really interested, I was really fascinated. I was originally just going to attend as a guest, but I am the makeshift host today. So for folks who don't know, I am Colin Gale. I am the president of Buffalo Niagara Human Resources Association. So it's my pleasure to hand things over to Scott. Just also to let everyone know on the call is being recorded, which I think you heard. In addition, there are in terms of your SHRM credits that will come in another email. Just letting you know for that. And then lastly, one more thing, I just want to let people know that on December 14th, we have our holiday happy hour. I will promote it again at the end of the call, but just sort of let people know. And with that being said, I'm going to hand it over to Scott.
Well, Colin, thank you. And I'm very pleased to be with you. We're going to talk a little bit today about the dual obligations that human resources professionals have. Employees who work for companies generally have only one obligation. It's to their employer. But we as human resource professionals have these dual obligations. And they're not only to our employer, but they're also to the employees who are under our care as professionals responsible for administering the system to protect them in the workplace. And so we're going to talk about when these two obligations potentially conflict and what you can do about it in particular when you might be facing retaliation as a result of your obligations to both. And we are going to be using in our discussion today a case study that will help us to understand what to do when these obligations conflict with one another. We'll also talk a little about how to stand up to authority if we disagree with instructions that we're getting that might interfere with our obligations as human resources professionals. We'll talk about the consequences of not standing up, and we will also finish up with some ideas about how to protect ourselves and our job as HR professionals when this happens. And as we indicated at the start, we're going to be using a case study, NAFTL versus Prince George's County Memorial Library System, an actual case that was filed, litigated all the way through jury trial. And it involves a fellow SHRM member, Jeff NAFTL, who was the former Human Resources Director of the Prince George's County Memorial Library System. Jeff filed a lawsuit against his employer, former employer, alleging that he was unjustly fired when he was fired merely for following company policy. And we'll talk about that. Colin mentioned who I am. I am also a SHRM member and an employment lawyer. I only represent employees now after beginning my career representing employers, advising human resource professionals and their obligations to the company. Now I represent, among others, human resource professionals, and I help them to identify their own individual obligations and their own rights under various laws and statutes. This is Jeff. He was hired in 2016 by the Prince George's County Memorial Library System. He was the Director of Human Resources, and you see a picture of Jeff here on your screen. So let's learn just a little bit about Jeff as an employee of the Prince George's County Memorial Library System. Jeff worked for the library system for 3 years at the outset with really little issue relating to his job. He was operating in his position at a very high level. The former CEO of the library system stated at trial what a difference Jeff made in the administration of the procedures within the library system. Indeed, Jeff wrote some of these procedures for the library system during his tenure. And then one day, a supervisor came to Jeff with a pretty standard request. There was an employee that they were having some problems with. They wanted to know what to do. She's still playing fast and loose with the call-out procedures, the manager said, something I suspect that you get in your jobs on a regular basis as human resources professionals, the inquiry from the manager about what's next. Well, Jeff, being the careful human resource professional that he was, said, let's look at the policy and let's examine both what you've done to date and what comes next. And this policy at the library system was a progressive discipline policy. The managers had provided an oral warning, a written warning to this employee. Her behavior had not changed. Indeed, it had lurched back into some of the most troubling behavior that began their concerns at the outset. So they turned to Jeff for help as the human resources director. I want to get a sense of, if I could, just quickly from those who are here. First off, have you ever dealt with a problem like this where managers come to you for advice and you look at the policy and you got two choices? One choice is you follow the policy, you go to the next step, and the other choice is to deviate from the policy. Wendy? Rebecca? What do you think?
I guess for me, it depends on if the manager followed the procedures and the steps in order, and how thorough they did would determine how I proceeded. If everything was in order, and they did a good job with documentation, then I would proceed to the next step of discipline. Otherwise, we'd have to start all over again.
And you talk about thoroughness and following the policy. Why is that important to you as a human resource professional?
Because that's what's documented in most cases in the handbook, and that's what any lawyer will probably look back as, did you do this, and this is what you have written. And so I think it's the piece of paper that keeps you out of court.
That is exactly what Jeff did. He looked at what they had done. He looked at the documentation that they had to support what they had done, to make sure that the previous steps in the process, in fact, had been done thoroughly. And he recommended, after finding that the steps had been followed appropriately and thoroughly, the next step in the progressive discipline policy. And this is where Jeff came across purposes with the CEO of the library system, because the CEO of the library system disagreed. And now we're at this inflection point, HR's twin obligations. And the first obligation is to follow company policy and the law. We juxtapose that with not following policy and the law, following, for instance, a manager's predilection under a particular circumstance. Following company policy and the law, it involves rules and defined procedures. And these procedures are based upon the law. They are the procedures that a company puts into place to give meaning to the law that is in force in the jurisdiction in which that company is operating. Following executive direction is different. It involves exceptions. It involves ad hoc decision-making, and it's based upon managerial authority and whim. So, are there risks in deviating from established policy at the request of a supervisor? Wendy, Rebecca, Kathy, what do you think?
Yeah, I think so. I think that to be honest with you, I do encounter this type of this type of a situation from time to time, working for a smaller company. But yeah, I mean, I think that the important thing is to stick to, you know, consistency is so very important. So there's no risk of perceived, even if it's perceived favoritism, because if something is run for an executive request, and then there's always that risk. And that is something that makes me, you know, can make I think it puts the company at risk and the HR professional at risk.
Makes you a little bit nervous.
For sure, yeah. Not super comfortable with that, but yeah.
Talk to us about perception. Why is that important?
Yeah, it could be something that could absolutely make sense. It could still be, it could be a deviation from the company policy, but something that is still within the realms of something that would make sense and be appropriate. However, if it doesn't matter if, because perception is in a way more important than the reality of the situation. I mean, you know, like just the same thing is intention versus outcome. You know, you always that, you know, at the end of the day, it's what it kind of looks like. Because as a HR professional, you're not going to necessarily, nor should you feel obligated to explain certain decisions to the entire company. So there's, you know, there would be that risk of maybe not knowing the entire story. If an exception is made, then there could be the perception that there's favoritism.
Thank you.
Yeah.
So
yeah, Scott,
Kathy,
this
go
is
ahead.
this is Kathy. You know, I worked in HR a very long time, and we had the situations all the time where we had a progressive discipline policy, but we would always have a supervisor in my office once a week wanting to go outside of the policy, no matter how well they've been trained, no matter how much they know, because they're trying to advocate that this situation is different. They just get tired of managing people in many cases. And from their perspective, I understand. I get it. I get it. Being on the floor can be very difficult, but it's a dangerous practice. And, you know, I learned my lesson the hard way early in my career, that deviating from the established policy for the request of the supervisor can get a lot of people into trouble. And just as the comments before about perception are huge from the employee perspective, and we had a non-union environment and wanted to keep it that way. So we really were very, very cautious about the perception. But, you know, the one time you make the exception for the supervisor, then there's another supervisor with another exception. And before you know it, you don't have a policy, you only have practice. Very dangerous.
Tell us about the lesson you learned.
Well, the lesson, I never got in big trouble or anything, but you know, you end up having to backtrack. You end up having then to correct things that have happened from an employee perspective. We had an issue where one of the HR managers that worked for me made a decision, and I supported it at the time, which was why it was my responsibility. You know, from a perspective of the facility director came to us. He wanted a different outcome than one that following the policy would have brought. And, we wanted to be real partners with them. It was very early in our careers. We wanted to help. We could justify why we felt we were doing these things. But down the line, it came to bite us again with another similar situation with another employee. So, we had to learn that kind of the hard way, that you can't be doing that. We have to be able to keep the policies the way they are, particularly for the employee piece. And I'm proud to say that, as we did that and as time went on, we remained a non-union facility, largely in part because of the fairness perception that we were able to do by following our policies. People didn't like the policies, but they knew what to expect.
Kathy, thank you. So let's talk about some of these risks that really echo what you both have talked about, Rebecca and Kathy. Let's talk about the risk to the company. Deviating from the policy against an employee, of course, may be discriminatory as to that employee. Deviating in favor of an employee may support the claims of others later on. So imagine for a moment a world in which the other employees, the perception that would have been created if Jeff hadn't suggested the next step in the process, which was suspension, and the message that would have sent to those employees who did arrive for their shifts on time, who did call out using the procedure that the policy required, and the impact on morale. Above, even above and apart the risk to the company, there is also the risk to us as human resources professionals when we deviate. Being blamed later on for not having followed the policy after the fact, and potential personal liability for having acted or not acting under certain circumstances. And personal liability is real. For example, these are statutes that allow an employee to bring a cause of action, not only against the company, but against the human resource professional that engaged in or ultimately violated the provisions of the Act. And look at some of these: the Family and Medical Leave Act, the Occupational Safety and Health Act, the Fair Labor Standards Act. These are statutes that employees are aware of and bring cause of action under regularly. The greater the participation in the action, the more likely that human resource professional is going to be included as someone who is individually liable. For example, if the human resource professional is at the meeting in which the discipline is implemented, discussed and implemented, if the human resource professional articulates the employer's decision to take the action in question, these are the kinds of things that potentially can open up the human resource professional to individual liability. So what do you do under the circumstances? In order to protect the company and to protect yourself, there are circumstances where a human resource professional, when faced with an instruction by a manager to take an action that they know is in violation of company policy and potentially the law, they have to stand up to authority. And in doing so, this is not easy. In doing so, there are there's a checklist that human resource professionals can follow in order to make sure that they have protected themselves in this circumstance. And the first is to identify a conflict with a company policy that the manager's directive conflicts with, or the law, and to identify that to the manager or the executive, to do it in writing. Something along the lines of, hey, John, look, I want to just raise with you a concern that I have about what you asked me to do in our meeting today. I've taken a look at our policy manual, and under the policy manual, what you're asking me to do may deviate from our policy as stated in the manual. I know you may not be fully aware of this, so I wanted to give you a snapshot of what that policy looked like and what it requires us to do under the circumstance, just to give you an opportunity potentially to rethink what you want to do here. I'm obviously ready to implement whatever it is that you decide, but I want to make sure that you're aware of where what you're asking me to do might in fact violate company policy. That kind of email done in a constructive way can go a long way in not only insulating you from potential blowback later on, but also to give that executive some pause to rethink what their directive is. If that doesn't work, then ask for an opinion from the company's legal advisor. Hey, John, I know that that I'd mentioned the policy to you, and that you said you still wanted to proceed nonetheless, even though I indicated that might be a violation of policy. I thought I might just suggest that we call Mary to check in with her and see from a legal perspective how she feels about this. You know, if she signs off on it, then I'm perfectly willing to implement it, but I'd like to just get her view on this and her legal opinion before we proceed. Again, proceeding on the advice of counsel can insulate you personally and insulate the company later on to an allegation that it wantonly violated its own internal policy. If a manager still insists on proceeding consistent with or inconsistent with established company policy, then think about potentially escalating a concern to a higher level. The audit committee, maybe going to another senior executive or the board, potentially establishing a paper trail of compliance here, triggering a compliance mechanism if that's available. For example, if you work for a publicly traded corporation, every publicly traded corporation must have an audit committee. Other companies who work in regulated areas have a compliance officer. Whatever that mechanism is, then following that path to trigger that compliance mechanism, and then acting under protest. We've talked about this. I told you that I think it might violate the policy, but ultimately you're responsible and in charge, and you're directing me to proceed, and I will do so consistent with your instruction. Of course, the final step is to maybe look for a different place to work. This is not easy for sure, but following this simple checklist can put you in a position where you are protecting yourself as well as the company. And let's look at what Jeff did. Jeff followed this checklist, at least the first three of the items that we went over, until ultimately he could go no further because he was fired. Okay. Protecting your own legal claims. If something like that were to happen to you, familiarizing yourself with the anti-retaliation laws, when you stand up to authority to engage in what the law calls, as we all know, protected activity, which may require blowing the whistle to senior management. And then, of course, following piece of advice that we give to managers all the time, which is to document everything that we do in our communications with those who are in senior leadership. Don't wait for things to get worse, because they're not going to get better. It's better to try to act early in this process. And ultimately, if something happens, then seeking counsel. The company's lawyer is not going to be able to represent you or advise you personally. So thinking about retaining your own lawyer to get advice under these circumstances. Okay. Now, Jeff did these things. He talked to a lawyer in the run-up to what occurred. First, the company lawyer, and then his own counsel when he was fired. He saved documents relating to the concerns that he had raised. And if you are faced with this prospect, say as little as possible, except the fact, of course, that you believe that any company action against you is because of the concerns you raised or your refusal to violate the law or company policy. At trial, it came out before the jurors that the CEO fired Jeff, she testified, because he lacked empathy. He was authoritarian. He was a disciplinarian. And this, the CEO said, clashed with what she intended to be a new library culture. And this is all notwithstanding the fact that Jeff followed all the rules and he performed at the highest level. He was the only person fired and with no progressive discipline. So the jury considered all of this. And they also considered the fact that there were individuals who were younger than Jeff, of a different race than Jeff, of a different gender than Jeff, who all received progressive discipline during their employment. Jeff was fired abruptly and for seemingly no reason, simply because he was following company policy. He was also replaced by a younger Black woman. The jury deliberated. This is the verdict form that they received. And they found that Jeff was a victim of age discrimination, that the library had violated the law relating to gender discrimination, race discrimination, and awarded $312,000 in damages, anti-discrimination and anti-harassment plan for the library, and training for the executives and the board. This verdict is currently under appeal. One of the important things that happened right after this was that the CEO was fired. So what can we learn from Jeff's case? The laws protect those who try to do the right thing. Standing up to authority is tough, but it's possible, and that we have options, even if we're fired. And now we are ready for some Q&A. And Jean, if you would, for me, if you would turn off our recording, please. We have a special